Welcome to today's video on the immigration dilemma many families face, the painful gap between hope and legal reality. First, we'll set the stage by explaining what happens when a detained person has significantly overstayed a visa and has weak ties in the United States. Next, we'll contrast two types of lawyers you might encounter and explore why outcomes often don't change even when thousands are spent. Finally, we'll arm you with a practical checklist to avoid unnecessary losses and set realistic expectations. Let's begin. Here's our roadmap. First, we'll outline the context and the hard truths affecting detained individuals with long overstays and limited U.S. ties. Then, we'll compare two attorney approaches. After that, we'll discuss how precedent restricts bond and why success is unlikely for many detainees in this category. Next, we'll break down potential costs. Then, we'll share concrete steps to vet attorneys. We'll also include quick quizzes to reinforce learning. Finally, we'll summarize the key points and next steps. Before we proceed, this is a general educational explanation, not legal advice. Immigration law changes frequently and depends on specific facts. If a loved one is detained, time-sensitive deadlines may apply. You should consult a licensed immigration attorney in your jurisdiction to receive advice tailored to your circumstances. Now, let's establish the core reality. Individuals who have significantly overstayed their visas and lack strong ties, such as a U.S. citizen spouse, minor U.S. citizen children, or substantial property or business holdings, generally have very limited options for relief from deportation. Consequently, paying thousands of dollars typically covers an attorney's time for attempting procedures rather than guaranteeing any outcome. Understanding this distinction is crucial. Let's visualize the typical decision path. After detention, the key threshold is whether the person has strong U.S. ties. If yes, there may be fact-specific relief options available, such as bond or certain forms of relief, depending on eligibility. If no, the likelihood of bond or other relief is minimal. At this juncture, clients often encounter two attorney archetypes: an honest practitioner who declines to take money when the case lacks merit, and a more optimistic practitioner who proposes procedural steps, such as a bond hearing, despite very low chances of success. The latter pathway often leads to significant fees with limited or no change in outcome. Let's compare the two approaches. The Honest Realist tells the client directly that there is essentially no viable case and declines the retainer, while explaining the reasoning. This approach reflects a commitment to professional integrity and client protection. By contrast, the Hopeful Opportunist focuses on procedural actions, such as attempting a bond hearing, even when eligibility is unlikely. While this may not be outright fraud, it often raises ethical concerns because it prioritizes billable activity over the likelihood of a meaningful outcome. Here is a rough snapshot of potential costs associated with long-shot strategies. Initial retainers can range from a few thousand to several $1,000s, often non-refundable. Bond motion preparation and hearings may add another substantial amount, even when eligibility is doubtful. Filings and service incur additional charges. Interpretation, translation, travel, and routine communication are also billed. In aggregate, families may spend several thousand to well over $10,000 with little chance of changing the result. These are approximate ranges and not quotes. Let's discuss why bond is frequently unattainable in these circumstances. Case law and agency precedent often emphasize strong community ties, stable residences, and low flight risk. Individuals with long overstays and minimal U.S. connections usually cannot meet these criteria. Consequently, filing motions or requesting hearings does not fix the underlying ineligibility. The result is that attorneys bill for the time invested, but the likelihood of release remains very low. This timeline illustrates the common progression. A person is detained, seeks multiple consultations, and hears from an honest practitioner who declines to take money. The person may then consult an attorney who proposes a bond hearing, pays associated fees, and proceeds. Frequently, the motion is filed and denied, resulting in financial and emotional costs. Only then do many families reset expectations, often returning to the original advice. There was no viable relief. Quiz time. If 3 experienced attorneys independently say there is no relief, what is the wisest next step? Option A. Pay a new lawyer who promises a creative strategy immediately. Option B. Pause and reconsider spending. Seek a final, clear explanation of why there is no relief. Option C. Insist on filing a bond motion regardless of eligibility. Option D. Switch to daily paid phone consultations to keep trying indefinitely. You may pause the video now to think about the answer. We will discuss the answer in the next section of the video. The correct answer is to pause and reconsider spending, seeking a final, clear explanation of why no relief exists. When several experienced attorneys independently agree that no relief is available, continuing to pay for attempts is unlikely to change the outcome and may lead to significant financial loss. Here are concrete steps to protect yourself. Ask for a candid, written assessment of eligibility. Request a roadmap that includes probabilities, not just procedural steps. Review the retainer for fees, refund policies, and billing increments. Seek at least 2 independent opinions before committing funds. Ask precisely what facts would need to change to make the case viable. Establish a budget cap and a stop-loss decision point. Keep thorough documentation of all advice and decisions. Let's unpack the ethics. Attorneys are generally compensated for their time and effort, not guaranteed outcomes. Ethical practice means declining to charge for a case that lacks a plausible route to success. In contrast, selling hope through procedural steps while knowing the probability is negligible may be legal but ethically questionable. The sequence diagram shows how money can be spent without moving the outcome, culminating in a denial and non-refundable fees. If immediate relief is unavailable, consider longer-term strategies. Waiting for policy or legal changes may be appropriate in some situations. Voluntary departure is a serious step that requires individualized legal advice. Meanwhile, building positive equities, such as community ties, stable employment, and clean records, and keeping documentation organized, may improve prospects if circumstances change later. Second quiz. Which statement best reflects bond reality for long overstay detainees with weak ties? Option A. A strong motion can override ineligibility. Option B. Eligibility turns mostly on facts like community ties and flight risk. Option C. Paying higher fees increases approval odds. Option D. The judge must schedule a bond hearing if you ask. You may pause the video now to think about the answer. We will discuss the answer in the next section of the video. The correct answer is that eligibility turns mostly on facts like community ties and flight risk. In these cases, long overstays combined with weak ties strongly diminish the chance of bond, no matter how detailed the motion or how much money is spent. To recap the essentials. Hope typically costs money, while integrity can save it. When several independent attorneys say there is no relief, it is time to reassess rather than continue spending. Bond outcomes are driven by facts, especially community ties and flight risk. Spend money based on probability, not merely on possible procedures. Finally, document all advice, cap your budget, and set a stop-loss point. In summary, long overstays coupled with weak U.S. ties typically yield minimal avenues for relief. Clients commonly encounter 2 types of attorneys, one who refuses to take money for a case with no prospects, and another who offers procedural steps with little chance of success. Costs can accumulate rapidly, even when outcomes do not change. Due diligence, multiple opinions, and budget discipline are essential to protect your family's resources. Thank you for watching. If this video helped clarify your options, please like the video, share it with someone who needs to hear this, and subscribe for more practical, straight-talk guides. In the comments, tell us what decisions you are weighing, and what information would help you most next. Your experience can guide others.